Good afternoon, everyone. My name is Kristen Solis. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program. For those of you that may not be familiar with us, we are a joint program with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys that will do their case pro bono. We handle all types of civil cases except for personal injury or cases an attorney could earn a fee on. And one of the big types of cases that we get through our office are probates. And the typical thing we see is the mother or father has passed away and left a house, and now the adult child is needing to get title to that house or to access mom and dad's very small bank account or whatever the case is. And of course, they cannot do it without the assistance of a pro bono attorney to help them through probate. So today we are blessed to have Jack Wilburn teach us all about what to do when there's no will, how to get those assets. Jack is a sole practitioner specializing in probate, guardianship, and estate planning. He has a bachelor's of music degree from McMurray University in Abilene. He has his JD from the University of Houston. He is a past chair of our probate section here in Dallas County and is just a wealth of probate knowledge. As Jack presents, if you have questions, please enter them in the Q&A section in the bottom of the Zoom, and Jack will attempt to go through those questions during his presentation. So without further ado, I'll turn it over to Jack.
Thank you, Kristen. And I love the use of the word attempt because that is an accurate description of what's going to happen here. I will try to keep my eye on that Q&A piece down there. And let me see here if I can share my screen and get the ball rolling here. Let's see. Okay. So we were just talking that I think I've given this presentation 4 or 5 times for various groups around the state and around the Metroplex. And I think I'm going to have to retire it. I think I've given it enough. The problem is I can't come up with a replacement. So I've been kicking around ideas like the guardianship gardener or the estate electrician. I just can't figure out how to do that. But everybody always laughs at the title of this presentation, but the way it started is it just occurred to me over the years that I am really nothing but a plumber. People come to me, they have a problem with essentially all we do in probate is move money from people who have died, money and assets from people who have died to people who are living. And a lot of times that happens without the need of a lawyer via non-probate assets. But if it's a probate asset or there's a clog, they come to me with their problem, and I look in my toolkit of tools I've got, like my plunger and my crescent wrench, and maybe it'll be something easy like that. And sometimes you got to get out something a little more heavy duty. But the bottom line is I'm really just helping people move assets from deceased people to living people. So that's where this title comes from. And again, if you've seen me present before, you know you're not getting out of here without a cheesy joke. So I went and found a couple of plumbing comics. I really like this one. I tried, Mick tried, heck, the whole maintenance department tried. Nobody can pull it out of there, but go ahead and give it a shot, I guess. And the bloodline of King Arthur rises once again. I like this one, the Shanolan School of Plumbing. When you can snatch this crescent wrench from my hand, little flusher, it will be time for you to go. And this speaks to everyone. Ooh, this not be cheap. Even from the beginning, they knew that plumbing wouldn't be cheap, and just like lawyers. Um, so you might ask, well, how often does somebody die intestate without a will? And research tells us that about 70% of Americans will die without a will. And so most of the people that are going to come to you are going to have some sort of problem that's going to involve not having a will. And so once someone comes in and you start asking questions, and you find out they don't have a will, then what? Um, and this is the most important part. You just got to sit down and talk. You've got to talk to them and figure out, ask questions about the assets they have, what the decedent owned, and how those assets were held. And what I tell people is, in my world, there's two kinds of assets. There's probate assets and there's non-probate assets. And non-probate assets, as you probably know, are anything that passes directly from the decedent to a beneficiary via some written mechanism, either a beneficiary designation on like a life insurance policy would have a beneficiary designation, or a lot of times a surviving spouse will come to you and she'll say, well, we had a bank account, I need to go through probate. Well, hold on. Were you both on that bank account? Mm-hmm. Well, most likely it's joint tenants with right of survivorship. So just take your death certificate down to the bank, and that'll work. And even sometimes assets that don't have an express beneficiary designation will, in their very language, like sometimes an employment, something that comes from an employer, a benefit will have language within it that will say, here's who gets this if there's no beneficiary listed. And so it may fix itself. A lot of these things will sometimes fix themselves. And if everything is non-probate, then you don't need to probate. And I'll say this, there's lots of people that come to me that have a will, and, well, I need to probate this will. Okay, well, hold on, let's talk for a minute. And you start talking to them, and by the time the person died, all they had was a bank account with a beneficiary, or that was joint tenants, and the IRA and the 401k all had beneficiary designations, and they were renting a house, and they didn't own a car. Well, I don't think we need to do probate for that. I think you can handle that outside of probate. So again, just because somebody has a will doesn't mean you have to go through probate. And a lot of times, a lot of people's assets are held as non-probate assets. And just a reminder, assets that are held in trust are non-probate. If someone has a bunch of assets held in a trust, that trust is going to pass outside of probate, and the assets are going to flow per the terms of the trust. And like we talked about, bank accounts, they may be joint tenants with right of survivorship. They may be payable on death. They may have a beneficiary designation, the same with the retirement accounts or IRAs. Those may have beneficiary designations or transfer via the terms of the contract. And cars. You may not know this, but you can do a transfer on death on the car title, or you can use an affidavit of heirship to transfer a car as well. So there's lots of hope for me. I used to freak when people came in and said they didn't have a will, but now it's gotten to the point where I'm surprised when they do come in with a will, and there very rarely is an instance that we can't solve when they've died without a will. Now, time out. I'll tell you this: as comfortable as I am with people dying without wills, obviously we want to encourage that. I'll say I'm more concerned about people losing capacity without powers of attorney, because the options we have, the tools in my toolbox for dealing with a guardianship or dealing with an incapacitated person without powers of attorney are much fewer than the tools I have in my toolbox for dealing with an intestate estate. So as you come in contact with people, be encouraging them, obviously, to make their wills, but also to have medical and financial powers of attorney to avoid that problem as well. So, all right. So what tools are in your toolbox if someone comes in and their loved one or their friend has died without a will? Here are the techniques for handling intestacy. You have, and we'll talk about these more in depth, but you have your determination of heirship, which is under Code Section 202. You have a court-created independent administration, which is under Code Section 401.003. And I'll tell you, if you're scribbling this down frantically, my understanding is at the end of the presentation, this will be sent out to everyone who's here. So don't worry if you miss any of these numbers or any of these specifics. You'll get a copy of this later. Let's see here. You have a dependent administration under 306.002. You have an affidavit of heirship. I touched on that briefly under Section 201. You have a small estate affidavit under 205. You have a version of a determination of heirship that involves no administration under 451. You have the family allowance and order of no administration also under 451. And you have administration of community property under 453. And you can even use the court to help you gain information about those bank accounts. We were talking about whether or not an account was probate or non-probate. Well, if the bank won't tell you, you can use the court to help you gather that information. So pretty much there's a tool for every problem you've got. And so I take a lot of solace in that and enjoy sharing that with clients. I like to say nobody calls me when anything good has happened. Generally somebody's died or lost capacity, and they come in and they're very worried. They're very concerned about how things are going to go. And I love sitting down and talking to people and just saying, hey, I understand, but look, here's an easy fix for this, and here it is. And I get a lot of joy out of that, and the clients appreciate it as well. It tends to take a little bit of pressure off of them. So, all right, let's talk about determination of heirship. So if someone makes a will, regardless of who their heirs at law are, they can make a will and leave their assets to whoever they want, as long as they have capacity and aren't subject to undue influence. But if those two things don't apply, they can make a will that leaves their property to whoever they want. However, if they die without a will, the state of Texas made a will for them. It's called the Laws of Intestacy. And the way you have the court lay that out is to follow the determination of heirship. So it's a judicial determination of who the heirs of the estate are. It is essentially having the court issue an order or a judgment as to who the heirs of a decedent are. Now, when you file it, every determination of heirship requires the appointment of an attorney ad litem to represent unknown heirs. Now, I'm sorry, that says $500. That's Denton County. If you're in Dallas County, you have to put up a $400 deposit before you can have your ad litem appointed. And so these are not inexpensive proceedings. You're already on a filing fee of $300 and an ad litem fee of $400 before you even really get started. It requires the hearing on a determination of heirship requires the testimony of two disinterested witnesses. It requires a proof of citation to all of the alleged heirs or waivers of that citation executed by each alleged heir. And so sometimes that can be easy. Sometimes you're just dealing with a surviving spouse and two kids. And sometimes I've got one coming up in a couple of weeks where there are 35 heirs. And don't ask me exactly how this happened, but I got a waiver out of every one of them. And Nathan Griffin tells me a story where he's got a case with, I think it's over 200 heirs, an intestacy with over 200 heirs. So these things can get a little convoluted and complicated, but the bottom line is you're going to either have to serve citation on every intestate heir, or you're going to have to get a waiver out of them. And so my point is, it's not super complicated. There's just a lot of hoops you have to jump through. You have to publish citation in the newspaper. Again, you have to have your ad litem appointed. Your ad litem has to do their due diligence and investigation. And hopefully all roads lead to the heirs that your client believes there are. But every once in a while, an heir will pop up out of nowhere, and you got to start over. But the bottom line is the court will determine who those heirs are, and you'll end up with a judgment declaring heirship, and you can use that to essentially show who owns property in an estate. So if you do that, you can also do what's called a court-created independent administration. So, in Texas, when somebody comes and we draft a will for them, we have them appoint an independent executor that will serve without bond and without court oversight to administer the estate. And there are lots of upsides to that and lots of reasons to do that. But if you don't have a will, we have a cheat here. Under section 401.003, we can ask the court to appoint an independent administrator for the estate. And if you're wondering, Jack, what's the difference between an administrator and an executor? An executor is someone who is named in a will. An administrator is someone who's appointed by a court. So if you've ever seen somebody that's a independent administrator with will annexed, that just means that they were appointed by the court as an administrator, but there is a will. So don't let those terms confuse you. But here's the kicker on an independent, a court-created independent. You have to have the agreement of all of the heirs. So if there's 5 heirs and 4 of them agree and 1 of them doesn't, you're not going to get a court-created independent. You're going to have to go with a dependent, and we'll talk about that more a little later. You will need what's called a designation, consent, and waiver from each of the heirs. That's essentially a notarized document that says, I designate Bob to serve as the independent administrator of this estate. I consent to his appointment as independent and without bond. And I also accept or waive service of citation in this proceeding. So if you're going to do an independent, you got to make sure you've got all of these things taken care of, or the court won't do it. Most courts require a simultaneous determination of heirship. A lot of people, including me, file this as a combination pleading. It's a court-created independent administration with a determination of heirship. I will tell you that most courts now require that you have 2 orders for that at the hearing, but you can file them as one pleading for the most part. Check your local jurisdiction to be for sure, but I can tell you in Dallas, Denton, and Collin, it's acceptable for right now. One of the main reasons to do an independent, and if it's appropriate under the circumstances, the heirs can waive the requirement of a bond, which can save you significant money in an estate. And I will tell you that for the most part, courts will not do this. They will not create an independent administration when there's a minor heir. So you've got, dad died a long time ago. Now mom dies, and there's 5 kids, and one of them's 14. In Dallas County and Denton County, you're going to have a hard time getting an independent administration. We have had success in Collin County, having Judge Copeland appoint independents where there are minor heirs. But just be aware what jurisdiction you're in and who you're dealing with. So as you're talking to your client and you're gathering facts and you're thinking, all right, this sounds promising. Everybody gets along. I'm thinking I could do an independent administration, a court created independent. And then they say, oh, or you ask, well, how old is Sally? Oh, she's 12. Ugh, dadgummit. So just be aware of that you may not be able to use this tool if you got a minor heir. I will say this, there is limited protection for your heirs in an independent administration. It's as much protection as you have with an independent executor, but it's not as much protection as you would have in a dependent administration that we'll talk about here in a minute. So you kind of got to weigh these pros and cons with your client and make sure they understand the benefit of an independent is it saves money. You're not having to go to court as often. Once you have the initial hearing and once you get your inventory approved, the court's pretty much done with you. So that saves a lot of money. But there's no bond, and independent administrators and executors need to be somebody that can be trusted with those fiduciary duties. So that makes it cost effective. Now, on the other hand, we have the dependent administration. So a dependent administration it does not require the agreement of the heirs. So this just happened to me a couple of months ago. I had 3 intestate heirs. 2 of them agreed. 1 of them didn't. It didn't matter that the 2 agreed. It's a veto power by an heir, and they would not agree to an independent. So we were stuck with dependent. And I talked till I was blue in the face trying to explain why it would have been a good idea to do an independent, but they don't have to agree to it. But the reason it's important is because it's going to save a lot of time and money. A lot of courts will require a simultaneous determination of heirship. In very, very limited circumstances, can you get a dependent administrator appointed without an accompanied determination of heirship. A dependent administrator is required to post a bond for assets that are not secured. So somebody has a house, you don't bond for that. You don't bond for dirt or land. You bond for cash and cash equivalents and cars and contents of the house and things like that. So, typically some of these bonds can approach six figures pretty quickly and go beyond that. And if someone is going to serve as a dependent and they're going to have a bond, they're going to have to get approved for the bond. So as you're moving towards court, you want to make sure that you get your client pre-approved for their bond, because there's nothing worse than going through all this rigmarole, going to court, convincing the court to appoint your client as the dependent administrator, and then finding out that they can't qualify for the bond. That is what we call a womp moment. And you have to go to the court and say, well, I need a new order appointing somebody else because my person can't qualify. So just be aware of that. A dependent administrator is required to file an annual account. That's something that an independent administrator is not required to do. So that increases expenses. But on the other hand, while it increases expenses, it also increases court oversight and gives heirs comfort that things are being done properly. So, if you've got somebody that you don't trust and they're serving as the fiduciary. You can not consent to the independent, let them be dependent, and let them file their annual accounts, and you can keep an eye on that. But again, that increases cost. Dependent administrator is also required to file a final account. There's differing opinions about this on independence. I don't generally close an independent administration. I just leave them open. They run forever. Some people think it's important to close independents, but there's no debate on a dependent. You have to close a dependent by filing a final account. It's just required. Dependent administration provides the most protection that you can provide for the heirs of an estate. It's the most court oversight. I call it, it's like a giant game of Mother May I. Everything you want to do, you have to ask court permission for. If you want to sell a car, you got to ask court permission. If you want to sell a house, you got to ask court permission. All right, quick question here. Can you briefly explain the process for getting a prospective administrator pre-qualified for a bond? So sure. Essentially, and I am not sponsored by this company. This is not a indication of any other company out there, but every bond I've ever gotten was through CPI bonding. And the way they do it is they have my client fill out an application. And I assume this is the way it would be for any bonding company, but we have them fill out an application. We send it in with a guess as to what the bond amount will be. And they run them through whatever process it is they run them through. I think it's essentially a credit check or something similar to a credit check. And they determine if they're a worthy risk. And they'll tell you, hey, I got Susan approved for a bond. She's approved up to $200,000. And you're like, yes, now I just got to keep the bond under $200,000. And so generally your bond company will have some sort of pre-approval application, and you can have that in your pocket as you go to court. And I think the judges appreciate when you have your client testify to, have you been pre-approved by the bonding company for a bond up to $500,000? Yes, I have. And are we only requesting, is our understanding that the bond should be approximately $250,000? Yes. And again, you've been pre-approved. Yes. That makes judges really happy. So hopefully that answers that question. But again, the dependent administration provides the most protection because everything the administrator does, I tell my clients, you can't wipe your nose without asking for court permission, pretty much. There are a few exceptions to that. You can pay taxes, insurance, and the bond premium. But beyond that, you better be asking for permission if you're going to spend money. So there is a lot of protection there. But with that comes cost. So just be aware of that. Let's see here. And it can be really expensive. So, all right. Now, maybe you don't need an administration. Maybe you just need to do an affidavit of heirship. That's under section 203 of the Estates Code. So when Kristen mentioned that we do work with DVAP, and my role there is they bring the DVAP paralegals in and they talk about their cases, and I listen to the facts, and then I sort of say, well, what if you tried this? And I'm going to tell you, if the facts are such that there's a house and no will, and there's really nothing else to be administered or concerned about, a lot of times we'll suggest trying an affidavit of heirship or doing an affidavit of heirship. It is not a court proceeding. It's a document that's filed in the deed records of the county, where I would file it in the county where the real property is located that you're dealing with. I am of the opinion that an affidavit of heirship is only useful when there's real property. I don't know that, well, in a car, I don't know that I've ever seen anybody go to the trouble of doing an affidavit of heirship for the stuff in somebody's house. It's not to say that you couldn't. I've just never done it. It requires two disinterested witnesses, and it requires the signature of all of the heirs. So, but I want you to notice this. Within that code section, it says the affidavit or instrument containing the statement has been of record for 5 years or more in the deed records of a county in this state in which the property is located. Basically, what that means is these things become, affidavits of heirship become real solid after 5 years. Before that, they're not as good. I'll just tell you anecdotally, based on my experience, we use these. Generally they come up when you're trying to sell a house. So title companies will take an affidavit of heirship, but my experience has been that affidavit of heirship generally has to be more than a year old, or maybe a better way to put it, the decedent has to have been dead for more than a year for them to take an affidavit of heirship. So if you've got somebody that just died a month or two ago and you're going to try to use an affidavit of heirship, you may run into trouble with your title company. It may be too fresh for them to accept. But you may be okay. Let's see here. Got another question. Would an affidavit of heirship also be sufficient if a potential client needs to get into bank accounts? I have not had any success with that route. We'll talk about another option here in a minute called a small estate affidavit. My experience has been I reach for this tool when the facts are that there is real property or a car. I haven't had any success with banks accepting affidavits of heirship, but that's just me. I I practice under something called the golden rule, which is not what you think it is when I say that. The golden rule is he who has the gold makes the rules. So when you walk into a bank, they've got the money you want. They generally get to make the rules. So when you walk into Bank of America with your filed affidavit of heirship, they can say, we're not taking that. And, there's not a whole lot you can do about it. So generally, that's where the small estate affidavit kicks in. But just be aware, this comes up a lot through cases with DVAP and just in general. The person's been dead a long time. They've been dead 10 years, and the family's just now getting around to dealing with it because they didn't need to deal with it before. Affidavits of heirship tend to work better in those situations, especially if you're dealing with a title company. But again, they're best. The sooner you can get them filed and get that 5-year clock running, the stronger they're going to be moving forward. So let's see here. All right. Now that leads us to the small estate affidavit. That was a good question because it leads us right into this next one under Code Section 205. A small estate affidavit, in contrast with an affidavit of heirship, this is filed with the court. It's can only be used if non-exempt assets do not exceed $75,000. So if you've got a bank account that's worth $5,000 and it's sitting at Bank of America, you can use a small estate affidavit. It does require the signature of two disinterested witnesses. Again, it also has to be signed by all of the heirs at law. It does not create an administration. It merely results in an order that says, hey, these essentially these are the heirs, and you can take that order to the bank and they'll pay out the money that they've got to the heirs that are listed in the order. Some courts will only approve a small estate affidavit when no real estate is involved. That's a court-specific issue. I will tell you there's an amazing small estate affidavit form and checklist on the Dallas County website that Judge Monroe has worked on over the last many years. Uh, I'm also going to tell you this: when it looks like a small estate affidavit is going to be the right tool to use, I used to try to charge people for these. I can't. How do I put this? I can't, in good conscience, charge them what it costs to do it when it can be done on a pro se level. So at this point now, I just give them the packet and tell them good luck. And usually they have success on their own. There's just I can't I can't charge enough to cover my time for generally what these are doing to make them worth my while and being fair to clients. So that's not a judgment. If you do charge for these, that's great. Um, but I will tell you, a lot of people don't know this, that they can be done pro se, and especially if you can give them that packet and they can handle it themselves. All right, so once you've run through that, now we'll kind of get into the more less frequently used tools. So what I just went through, those are the big tools. Those are the plungers, the crescent wrenches, the the snake, the liquid plumber, all of that stuff that somebody would use on a regular basis. Now we're getting to things that are a little less used a little less often, maybe a little more exotic. I hate to use the word exotic because, it's law. There's nothing exotic about it. But one of the tools you have is something called a determination of heirship and order of no administration. So this is a completely discretionary thing. Again, you file a determination of heirship, just like we talked about earlier. It's all of those same procedures and expenses and all of that. But you tell the court and you ask the court to sign an order that formalizes the fact that there's a determination of heirship, and it tells you, and it verifies or puts in writing and in the form of an order that there's no administration necessary. And I've used that every once in a while. It does the same thing as a determination of heirship. It just gives you a little bit extra meat on the bone by saying, yeah, we did this determination of heirship, but don't expect us to open an administration because there's not one necessary. So that's another tool. Another thing you can do is file an application for family allowance and an order of no administration. So under 451, there's a procedure for a court to dispense with an administration if the decedent is survived by a spouse, a minor child, or an adult incapacitated child, and the value of the estate, not including homestead, exempt property, anything like that, does not exceed the family allowance. So essentially, the administration is not necessary because there'd be no property for the decedent's creditors or heirs at law to receive beyond the family allowance. So you kind of have to do a cost benefit analysis calculation and say, all right, well, there's $25,000 in the estate. The family allowance would be $50,000. Boom. There's not going to be enough left over for anything else. Let's just do this. And to avoid plagiarism, that comes straight out of Professor Byers' 2019 Texas Estates and Trust Codes. He lays it out pretty simply there. It's really just, is it worth doing? Can I do it? And sometimes you can and sometimes you can't, but that's another tool in your toolbox. Okay, administration of community property under 453. If you have done guardianship law and are familiar with this concept, there's something called community administration that we frequently use to avoid a guardianship of the estate when you've got a husband and wife situation. This is that same concept applied to probate rather than guardianship. So it permits the surviving spouse to administer the community property in both testate and intestate situations. So ooh, look, it's the rare tool you can use in both situations, both intestate and testate situations, but it can only be used provided that no personal representative has been appointed. And this is also sometimes called an unqualified community administration. Uh, if you hear that term, this is what they're talking about. It's just a way for a surviving spouse, if all we're dealing with is community property, is to let them do it without jumping through a bunch of extra hoops. Let's see. If you have a situation where you don't know if your bank account is a probate or a non-probate asset, and the bank's not being nice enough to tell you that, if someone dies without a will and they own a bank account that has funds which do not pass to another person under the terms of the account, an interested person may apply to the court for an order requiring that the bank tell you the balance of the account within 90 days. This is before letters are issued. This is before there's been an application for the appointment of a executor or administrator, or it can still be pending. This is a fairly new procedure that was added in 2015, and it helps heirs figure out what the appropriate administration method is. So, this happens all the time. I'll be talking to somebody and I'll say, well, if it's less than 75 grand, we can do a small estate affidavit. And invariably they say, well, we don't know. The bank won't tell us. Then you go through all the easy tricks. Well, did you check the mail to see if there's a bank statement there? Is there any way you have of figuring this out? No, we don't know anything. All right, I guess we'll have to file this and see if we can force the bank to tell us how much is in the account. Let's see, another question. Notwithstanding the wording of 205.001, can a small estate affidavit be used if the decedent died without a will? Not in my experience. I believe that small estate affidavits are only available if you died intestate. That's been my experience. And but if you don't ask, they can't say no. So it doesn't hurt to try, but I've never had any success with that. Let's see here. So again, if you can't figure out, or the bank won't tell you, you can drag them in front of the judge and make them tell you, and they've got 90 days to tell you after you get that order. All right, so it's all well and good to do a determination of heirship, but you might be saying, but Jack, how do I know what heir gets what? I've got a surviving spouse and 2 kids from prior marriage, or this guy died with no wife and no kids, but he had a mom and 2 brothers. So you have to understand the laws of intestate succession at that point. And so if someone dies without a will, like I said before, the state of Texas has a will for them, and these laws of intestacy apply. And it's under section 201 of the code. And I'm going to see if I can do this. I'm going to try this. Forgive me if this doesn't work. Do me a favor. If you're on chat, if you can see that chart, just tell me you can see that chart, because I'm flying blind here on Zoom. Let's see. Oh, all right. Thank you, Darla. Let me try this. You're going to have to see my ugly face for a second. Let me go back. Boom. Share. All right. Now, hopefully you can see that. This is a handy dandy little chart that this actually came out of Collin County. A lot of courts have this chart outside of their courtrooms. If you're like me, all of these words are in the estates code, and I can read those words and read those words and read those words, and then read those words some more. And I can get confused. But if you show me a pie chart, I can figure that out. So this is just a handy visual reference. And it breaks it down. If someone dies and they're married and they have kids, it tells you whether or not if community property or separate property, if it goes to the surviving spouse or to the children. It just kind of breaks down everything. It tells you if they're single or widowed with no children. This is just a great reference to have handy. I keep it saved to my server. Um, you know, I'll tell you this, I do nothing but probate and guardianship. I've been licensed since 2003. And I'm not embarrassed to admit I have to pull this chart out because sometimes you just get wrapped around the axle. You're like, wait a minute, what happened? And what's going on here? And it just helps me to have this as kind of a visual reference. But when you get when you receive the presentation via email, hopefully that hyperlink to this chart will be in there, and it comes in really handy. Let me go back to the presentation. All right, so don't lose that. That'll be your best friend. And there it is. But like we talked about, now this is always fun to talk about. You may or may not have ever heard the word moiety. I'm not 100% sure I'm saying that word right. I say moiety. It's under section 201.001. And when does this come up? It comes up when somebody has died and they don't have anybody that's a close relative. So either they were married and their spouse is dead, they had kids and the kids are dead, but they never had kids, never married, mom and dad are dead, no brothers and sisters, nothing like that. You're just kind of looking at a person on an island that doesn't have any close relatives. You have to take them and divide them into two moieties. There's a paternal moiety and a maternal moiety. And essentially what you do is you take half the estate and it goes to the paternal side, and you take half the estate and it goes to the maternal side, and you go up and out until you find a common ancestor. And inevitably, the way this works is one moiety has 57 people in it, and one moiety has 3. And so, these 3 heirs are over there collecting big checks, and these 57 heirs are over here collecting smaller checks. And if they ever talk to each other, sometimes people get mad. They don't understand why their share's so small. I'm like, well, I'm sorry that your half of the family was so fertile or so numerous, and I can't help that the other side was less numerous. But the bottom line is, and generally, if you get into a moiety situation, you might need to engage someone called a forensic genealogist that can help you, because we're talking about people that nobody knows exist, and you're going to have to do some genealogical research to find those people. But just think of it this way. You're going to divide their estate in half. Half's going to go to the maternal side, half's going to go to the paternal side, and it's just going to divide that way. And so we've got a little bit of time for some questions. I like to add this at the end because it's fun. Proof I'm an actual plumber. That's me and Jefferson, the Walker Coonhound, helping me do some plumbing. That was not staged. I was literally doing plumbing work, and I said, hey, take a picture of me so I can add this to my presentation. If you know me, you probably know Jefferson. Jefferson has his own Instagram account. But that is it. We've got some time for questions here. If you want to throw questions up on the chat, I've got a few minutes to answer questions here. I'm happy to share what I know. I know that Maricela is going to provide the MCLE credit. There's the course number. If you're having trouble seeing it, it's 174117165. And thank y'all for having me. You have participated in the very last ever public presentation of the probate plumber. It is being retired. I will have to come up with something different because I think I've given this thing 5 times now, and we're going to put it out of its misery. But hopefully you learned something. The most important thing is just knowing the court you're in and understanding your clients and their assets, and being able to help them in their specific situation, and understanding the specific judge that you are dealing with and what they are and aren't willing to do. So let me check the chat here. Or the Q&A. I must have answered every. Okay, here we go. How do you get an executor to present the will to the court if they refuse to appear before the court? Do you have to have them served? So I send a demand letter. There's a code provision. I can't think of it right off the top of my head, but there's a code provision that says if you're in possession of a will, you either have to file it with the county clerk. And so I just send a certified letter in the form of a demand that gives them a time frame. You've got X number of days to present this will, either by filing it with an application or tendering it to the county clerk or the probate clerk. Then if they don't comply, there's some penal measures in there. You can show cause them. And if I remember correctly, and I usually copy and paste this and put it right in the letter, it talks about what happens to them. And I think it goes all the way to jail. It's been a long time since I sent one of those letters, but I've never gotten to the point where I had to throw somebody in jail. Usually once they see the code provision that talks about what happens to them if they don't comply, they'll generally comply. And let me say this though, sometimes refusal to tender it is I don't have it, or there isn't one. And no matter how convinced your client is that there's a will and that Billy Bob has it, there's a chance that there isn't a will and that Billy Bob doesn't have it. So sometimes, I guess you could have them sign an affidavit that says, I don't have a will, I never saw a will, if you needed that sort of protection. Let's see. How do you force a party holding intellectual property of the deceased to turn it over immediately to avoid it being destroyed? I think I would probably follow a temporary administration and have the court appoint a temporary administrator that would be given the authority to marshal those assets. I think that'd be the easiest way to do that. So, well, if somebody's ignoring a court order and you have a temporary administrator, that's on the administrator to show cause the person that's not obeying their instructions and drag them in front of the judge and let them explain that to the judge. That's the way I look at that. And again, if they're ignoring orders, it can end up in contempt. So, if, that's how I'd handle that. Let's see here. Any other questions? If client is indigent, does that waive the fee for the ad litem? Kristen, are you there? I think that is the case. I think we're able to get the court to waive ad litem fees in indigency cases.
I am here, and it actually, if I remember correctly, it depends on the court. Um, we've had different luck in different courts. I believe court 2, what they do is they don't waive the ad litem fee, but they issue an order in which they put the ad litem fee as a judgment against the estate. I think that's how they handle it. So it's just going to depend on your court. But as of yet, we haven't had anybody to have to pay that $400 upfront yet.
And correct me if I'm misremembering this, Kristen. I also believe there have been times where we've been able to get the court to appoint a DVAP ad litem. And what I mean by that is somebody that says, I'll be the ad litem and I won't charge. And that kind of fixes that problem as well. But it's been a long time.
That's correct. And again, it's going to be based on the courts. Some courts will let us find somebody to serve. Some courts will go ahead and appoint their own ad litem and then charge the county for it.
Yeah. So there should be some options there. Let's see. I see a question pop up. If there is an LLC business with husband and wife and there is no will, does the business go through intestate division of heirship? First, you got to look at the operating, the documents that created the LLC and any documents that are related to the LLC. If nothing like that exists, then I think those ownership interests are passed through intestacy. Now, ownership interest and control are two different things, but that's my understanding of that. So, all right, Miss Marasala, anything else for us?
No, thank you, Jack, for presenting this afternoon, and thank you everyone for joining.